Madam Speaker, I beg to move that a bill entitled An Act to Amend the Companies Act, Chapter 81, Number 1, to make provision for the role of the Chief State Solicitor as the official receiver be now read a second time. Madam Speaker, as stated, the purpose of this bill is to amend the Companies Act, Chapter 81, Number 1. The amendment proposed is a discrete one, which is necessary to fill a lacuna in the law created by the repeal of the 1916 Bankruptcy Act as amended, when the current Bankruptcy and Insolvency Act, Chapter 970, entered into force. The appointment of the official receiver was formally made under Section 73 of the 1916 Bankruptcy Act, now repealed. That section provided as follows: 73(1). There shall be in the public service an official receiver of debtors' estates. Such receiver shall be an officer of the court in its jurisdiction of bankruptcy, and judicial notice shall be taken of any appointment of a receiver pursuant to this section. 73(2). A person acting as receiver shall, during his tenure of office, have all the status, rights, and powers, and be subject to all the liabilities of the receiver, and all the estates, rights, and powers vested in the receiver shall, during the tenure of office of an acting receiver, and without any conveyance or transfer, vest in such acting receiver. Madam Speaker, in 2019, the Companies Amendment Act was enacted to effect miscellaneous amendments to the Companies Act. Section 10 of that 2019 Amending Act amended Section 42 of the Principal Companies Act by way of a new subsection 4, which provided that, quote, for the purposes of this section, that is to say, Section 462 and Section 463, the official receiver shall be the Chief State Solicitor. However, that amendment did not sufficiently take into account Section 366, I beg your pardon, of the Principal Companies Act, which provided as follows, quote, for the purposes of this act, official receiver means the official receiver attached to the court for bankruptcy purposes and includes any assistant official receiver. Unquote. I stress attached to the court for bankruptcy purposes because we will appreciate, Madam Speaker, that that was a reference back to the repealed 1916 Bankruptcy Act, Section 73(1) and Section 73(2), which I have just referred to. The 2019 Act therefore created a lacuna, did not cure the lacuna in the law created by the repeal of the 1916 Bankruptcy Act, and made only narrow provision for the Chief State Solicitor to be the official receiver under two sections of the Companies Act, that is to say, Sections 462 and 463. The 2019 amendment did not cover the other sections of the Companies Act which make provision for the official receiver to act without a definition of who is the official receiver other than the Chief State Solicitor. The bill before the House today is intended to address the existing lacuna by amending Section 4 of the Companies Act, the definition section, to expressly designate the Chief State Solicitor as the official receiver throughout the Companies Act. With this amendment, official receiver will be properly defined to apply consistently throughout the Companies Act, and Sections 366 and subsection 4 of Section 466 are no longer necessary and so are to be repealed. Madam Speaker, I beg to move.